Nothing is more important than protecting children, society's most vulnerable population. However, the child welfare system too often violates the rights of parents without due process and removes children from parents without justification. The abuse and exploitation of children by the very people and programs who claim to be protecting them is now so common and has been exposed in so many scholarly studies and popular accounts that one wonders why it's permitted to continue. Since at least the 1980s, scholars like Douglas Baskerville have warned that a flood of unfounded reports endangered truly abused children. In recent years, serious questions have been raised by critics about whether innocent parents are losing their children because of false or exaggerated accusations of abuse. There is an anti-family bias that pervades the policies and practices of the child welfare system, according to Jane Snitzer of the Children's Defense Fund. Children are inappropriately removed from their families. Part of this debate has raged within the child welfare profession itself, where some have alleged that children are removed unjustly and unnecessarily from parents in staggering proportions. A California commission concluded that the state's foster care system runs contrary to the preservation of families by unnecessarily removing an increasing number of children from their homes each year. Children everywhere are removed from their parents without a warrant when one should be obtained, says California Attorney David Beauvais. Parents are often tricked or intimidated. Courts too often rubber stamp Child Protective Services recommendations, and hearings are confidentially held. There's no public access and no media scrutiny. Once in the system, parents are well on their way to losing their parental rights. Writers such as Ross Park and Armin Brott, Dorothy Rabinowitz, Richard Wexler, Dean Tong, Dana Mack, and Sylvia Ann Hewlett and Cornel West have demonstrated the political and financial incentives that induce prosecutors, family courts, and child protective services to exaggerate and even fabricate charges of child abuse against parents in order to take away their children. By far, the most powerful incentive to rubber stamp an abuse charge is financial, argue Park and Brott. A San Diego grand jury investigation revealed a system out of control, with few checks and balances and little balance. This system, where justice is blocked by confidential files, closed courts, gag orders, and total statutory immunity for judges and social workers, has isolated itself to a degree unprecedented in our system of jurisprudence and ordered liberties. Like child support enforcement agencies, Child Protective Services blur the distinction between social work and law enforcement. In effect, they constitute another form of plainclothes family police. Although spoken of in terms of social services, writes Susan Orr, the child protective function of child welfare is essentially a police action. Yet, because they're not called police, these social workers aren't required to follow due process procedures, nor are the courts before which parents accused by them are summoned. Orr calls Child Protective Services the most intrusive arm of social services because of their power to remove children from their parents. Yet, because the parents are seldom charged criminally, they're not afforded due process protections and aren't able to defend themselves in proceedings that are often secret and without public record. The child protection system is built upon the notion that child maltreatment is remediable with the right therapeutic treatment, Orr observes. By forsaking the courts of criminal law, in which determinations of justice and injustice are made and punishments meted out, child welfare agencies took on the much larger task of attempting to heal family members who've gone wrong. This system of therapeutic law enforcement, applied in the cases Orr describes mostly to single mothers and some intact families, is precisely what fathers face on a much larger scale in the same courts and bureaucracies through involuntary divorce. The grand jury report also emphasizes the role of social workers as plainclothes police that, in practice, eclipse the regular police. We find that some police officers abdicate their role as fact-finders to the social worker, they write. Detectives will integrate elements of a social worker's investigation into their own reports instead of performing an independent investigation. Police are generally held to higher standards of evidence than social workers, who can pursue cases even when police conclude that insufficient evidence exists. When police determine that they can't find sufficient evidence to charge, the criminal case is usually dropped. Yet the civil case may proceed in the juvenile or family court in the absence of evidence. Most state agencies that deal in the areas of child protection are primarily autonomous, with little, if any, supervision from or accountability to anyone, writes Dean Tom. While they can remove children from a home and file a charge without presenting any evidence, they can't be personally responsible for their own actions. This is aggravated by a bureaucratic culture that threatens both fathers and mothers, including intact families. Some have suggested the rise of a new class of professionals: social workers, therapists, foster care providers, family court lawyers, all of whom have a vested interest in taking over parental function. Government bureaucracies that have assumed the role of protector over children whose fathers have been forced away also develop a professional interest in eliminating their competitors. These are people who are given an enormous amount of power, says Melvin Geyer, a psychiatry professor at the University of Michigan and a practicing attorney, and they routinely abuse that power. The San Diego's grand jury's report also emphasizes that social workers are perceived to have a nearly unlimited power and quotes one witness, "Power corrupts. Absolute power corrupts absolutely." Total immunity enjoyed by social workers is absolute power. They're even empowered to punish their critics. Parents and therapists have testified that in many cases, social workers have been allowed to retaliate. On September 21, 2004, an order of arrest was entered by a magistrate in Georgia against Stephen Lee Johnson for his website criticizing the state's Child Protective Service. The order followed threats of lawsuits by state officials against Johnson. This lack of due process protections in the child abuse industry, as one social worker calls it, has resulted in a presumption of guilt similar to that pervading domestic violence and child support. "When I started working, we tried to prove a family was innocent," she recounts. "Now we must assume they're guilty until they prove they're not." In Massachusetts, as elsewhere, allegations are substantiated not by a court proceeding, let alone a jury trial, but by administrative personnel in the Department of Social Services, which issues letters stating, "At least one person said you were responsible for the incident and there was no available information to definitely indicate otherwise." Here again, the burden of proof, contrary to every other area of our judicial system, is on the alleged perpetrator to prove his innocence. The San Diego grand jury describes the Soviet logic by which justice is rigged against fathers and anyone who stands by them. Ironically, denial is taken as evidence of guilt, they found. Unlike any other area of our judicial system, in juvenile court, the alleged perpetrator doesn't have to be proven guilty in order to achieve a true substantiated finding. If a father denies molest and a true finding is made, he suffers the ultimate catch-22. He can either admit and take a chance that the department will allow him to begin reunification with his family, or he can deny and no reunification will occur. If the spouse supports her husband's denial, she is accommodating his denial, and she too will not be allowed to reunify with the child. If the child denies the molest, this can be seen as part of a child abuse accommodation syndrome and an additional reason why the child should have no contact with the parents. Thus, all members of the family can deny a false allegation, and in each instance, the system uses the denial as evidence of guilt. As with domestic violence, the accused parents must undergo a new therapy program that requires confessing. The only way to complete Parents United is to admit the molest in San Diego. Not complying is grounds for termination of parental rights. Documented cases also exist of social workers falsifying transcripts of interviews with children to frame fathers. Also, like domestic violence, there is little doubt that by passing due process procedures, not to mention holding someone's children, creates pressures for guilty pleas by the innocent. The grand jury describes the likelihood that a charge will produce a plea to a lesser offense. Penalties for conviction are very high, and the cost of a defense prohibitive. Numerous defense attorneys testified that they allow and even encourage their clients to plead to a minor charge even when they're certain of the client's innocence in order to facilitate reunification of the family. Here again, the better safe than sorry rationalization for these procedures isn't wholly plausible, since such practices may create more abuse than they present. The Children's Project of the American Civil Liberties Union reports that children in foster care are 10 times more likely to be maltreated while in the custody of the state than in their own homes. Similar findings of widespread abuse in foster care are well documented. In essence, standards of proof and due process protections should be strengthened to prevent harming innocent families. Simultaneously, preventing child abuse must remain a foremost priority. Pursuing this balance responsibly would serve both parents and children. The child welfare system has overreached in many cases, but with reforms can still fulfill its vital mission. Written by Dr. Stephen Baskerville, taken from his book, Taken into Custody, The War Against Fathers, Marriage, and the Family, and produced by the Law Center, the creator of the Family Court Custody Boot Camp, revolutionizing family court litigation for self-represented litigants. Click the link in the description portion of this video to learn more about them.